Hello everybody, my name is Roshini Vinod from the Department of Commerce, and today we will be dealing with doctrine of ultra-vires. So there are some very important doctrines or principles as far as the Companies Act is concerned. This is one of them. Now as far as doctrine of ultra-vires is concerned, now at a company, a public limited company or a registered company, there are certain objectives as far as the registered company is concerned. So the main idea behind this doctrine is that the company should not act beyond the powers with respect to what is mentioned in the object clause of the Memorandum of Association. So let us look at this in detail. Let us look at the meaning of the term ultra vires. Now, ultra vires is a Latin term which means beyond the powers of. Now, this particular doctrine says that as far as a company is concerned, as far as a company that is registered under the Companies Act is concerned, it is not supposed to act beyond the powers of the Memorandum of Association. So, the Memorandum of Association is the basic document as far as a company is concerned. Now, when you take the Memorandum of Association, there is a clause called Object Clause. So, it is in the Object Clause that the main objective behind why the company has been formed is mentioned. So, as far as the company is concerned, it should not go beyond the powers mentioned in the Memorandum of Association. So, whatever is coming or whatever the company is doing, that is within the scope of what is mentioned in the Memorandum of Association. It should not go beyond that. Now, the one main thing regarding the ultra vires doctrine is that even if the entire shareholders of the company come together, entire directors of the company come together and try to ratify any clause that has been put forward in the say annual general meeting of the company, but it is ultra vires the Memorandum of Association, or rather we can say ultra vires the company, then we can say that it cannot be, it is not applied or it is not applicable. So as far as the company is concerned, it has to act within the scope of the company and within the scope of what is given mentioned in the object clause of the company. Now suppose if it is beyond the object clause, even if the entire shareholders come together to ratify this by passing a special resolution or some other if they come together and sign a notice also, it will be considered as ultra vires only, and it will be completely, it will be considered totally void. Now, what is the purpose by which you have a clause or you have a doctrine of ultra vires? Now, as far as a public company is concerned, there are a lot of investors, there are a lot of creditors as far as the company is concerned. So, they would have read the Memorandum of Association, they would have gone through the object clause of the company, and that is how they would have decided to invest in the company. So, suddenly, what happens one fine day if they decide to change what is given in the or they decide to change the object clause, or they decide to bring in a new object with respect to the company, then that becomes ultra vires. So, in order to safeguard the interests of the investors as well as the creditors who have invested in the company, that is why there is a doctrine of ultra vires. So, this is introduced in order to safeguard the creditors and investors of the company. Now, what happens is that whatever money that these investors have put in, they can be confident that the company would use that money only for the purpose which has been mentioned in the object clause of the Memorandum of Association. So it prevents the company from using the money of the investors other than for the purpose that is mentioned in the object clause of the memorandum. Now it prevents wrongful use of the company's assets, which thereby protects the creditors of the company. Now, creditors at the same time, as far as a creditor is concerned, if there is a non-repayment from the side of the company, then they have a charge on the assets of the company. So, with the help of this doctrine, the rights of the creditors as well as rights of the creditors are also protected because the company's assets are not used for any other purpose. It prevents directors from diverting the object for the company has been formed and hence constantly examining the activities of the directors. Now, the directors also have a vision as to what the object of the company is and what is the purpose by which their how they have to work for the company is clearly mentioned because you have an object clause in the Memorandum of Association. For the same reason, their vision is also not directed. They have their focus on the object clause of the company. Next, let us see the scope of the doctrine. Now, this applies to those companies that are incorporated or registered under the Companies Act. So that means it is not applicable for unregistered companies. So you have unregistered as companies like sole proprietorship, partnership firm, etc. So this particular doctrine do not apply to unregistered companies. Now, in case there is any illegal transaction that is carried on by the director or the employees of the company, even that doesn't come under the purview of doctrine of ultra vires. So that is again it doesn't come under the scope of the doctrine. So it is strictly with respect to what is mentioned in the object clause of the Memorandum of Association. So the scope is limited to that, and it does not involve unregistered. So the same thing does not apply to unregistered companies as well as any illegal transactions that is carried on by the directors or shareholders or members of the company. Now let us look at the exceptions to the rule of ultra vires. Now there are basically two exceptions to the ultra vires clause. Now if the clause is ultra vires the directors, then the shareholders have the provision to ratify this by passing a resolution in the annual general meeting. So they can make it intra vires the directors, and they can carry on the process up likewise. But the same thing, the shareholders have the right to do it. But as far as and if it is ultra vires the articles, so there is one clause that is beyond the powers of the articles. That also can be ratified by the shareholders by passing a special resolution in the annual general meeting of the company. But then, just to remind you, as far as if it's ultra vires the company or ultra vires the memorandum, then it cannot be ratified. Now, what are the consequences of those transactions or contracts that are got into which are ultra vires the company or the directors is what is given in the consequences. Now, if any contract or any act that is made by the company which goes beyond the powers of the directors and the company is completely void and inoperative. So completely void means it is void ab initio, or it is void from the very beginning, and it is not binding on the company. So even if there is a party who has gotten into a contract with the company which is beyond the powers of the company, it will not be binding on the company for the future also. Now, what are the effects of the doctrine is what is given. The first effect can be an injunction order can be issued by the members of the company affected by this particular doctrine against the company. The second the second effect we had discussed before also, it's as far as an ultra vires contract is concerned, it is void from the very beginning. So for the same reason, it is not binding on the company at all. And the third one, the directors can be sued for breach of warranty. So the directors are expected to act within the scope of the Memorandum of Association, or within the scope of the object clause of the Memorandum of Association. If they are going beyond that, then they'll be liable for breach of warranty. That's all for today's session. Thank you so much.